So NERP, or Northwest Human Rights Project, we're the only organization in the entire state of Washington that provides comprehensive immigration legal services to low-income immigrants and refugees. So we focus primarily on direct legal services, so actually representing and helping individuals in their cases. And we do just about everything in immigration other than employment visas, because the employers handle that, and none of our clients qualify anyways. And student visas, because the schools handle that. But everything else, in terms of family petitions, asylum, representation, immigration court, and implication defense, we do. We also engage in impact litigation, which is those class action lawsuits that get us in the newspaper, although honestly, they make up so little of our actual daily work. It's usually when we're doing our direct legal services and we basically see a lot of problem going on, and then we decide this, like, we can't fight this on an individual basis. We need to go higher up. That's usually when we get involved in impact litigation. So it's always kind of stemmed out of our direct legal services. And it's not just us trying to invite ourselves into the global debate. We also do systemic advocacy. Washington is actually not a bad state to be in for immigrant rights work. So we often work with or consult with in Olympia about issues about DACA, about kids, and actually one of the things I'll be talking about is actually something good news that came out of Olympia this year too. And we also do community education like this, but also to communities that are actually affected. So really since the election, since the inauguration, since the election, even before, we've been getting calls to do communication in just about every corner of Washington. So we go out to Forks, we go out to the islands, we go out in Eastern Washington and do these mass talks to people, especially since in the last couple of months, a lot of DACA workshops, trying to get people to let them know what's going on, what they can do, and help them scramble to apply for renewals if they're eligible. And then, as I mentioned, we have our headquarters in Seattle, but we also have an office in Tacoma, which serves primarily the detention center down there. And we also have 2 offices in Eastern Washington, in Central Valley area, in Wenatchee and Granger, which serve primarily the farm working population. And all of our staff are at least bilingual, most of them are bicultural, so we do serve a pretty diverse population in our staff and front staff. I was putting this slide together last night because things are changing so fast I constantly have to update it. And it's just so depressing. It's just listen to all the horrible things since January, really, for my field. So if y'all remember, January 27th, just a few days after, President Trump signed an executive order issuing basically the first travel ban. It banned entry for 90 days from citizens of 6 countries, namely Syria, Iraq, Iran, Libya, Somalia, Sudan, and Yemen. And then indefinitely host refugees from Syria. It was mass chaos. I mean, they didn't even consult with anyone. Even the agencies that were tasked with enforcing it had no idea what was going on. So led to all the chaos at the airports, the mass protests at the airports, lots of lawsuits. I think at one point I counted at least 40 different lawsuits going on. Us being one of them. Our executive director was actually at the airport on Saturday morning, and we pulled 2 people. We got emergency injunction from the judge, pulled 2 people off of a plane that were meant to be deported. While the protest was going on outside, and then he stayed with one of them overnight to make sure that they were going to transfer him to the detention center. And then they got released at 9 a.m. next morning. 6 a.m. our time, because we had to wait for the DC office at 9 a.m. to open so that they can issue them and actually release them. So we filed a lawsuit, and of course, ACLU, Bob Ferguson's office, AG's, Hawaii, all over really. So we got, and through all that collective effort, so there's lots of injunctions and blocks, temporary blocks, more permanent blocks that got into place. And then the Trump administration tried to basically work around that by issuing a second travel ban in March, which this time brought entry for 9 days international 5 countries. So Iraq was removed, and then I'll talk about why they got removed and all that ensued. And then also brought refugees entry for 120 days. So the deal with Iraq is that they basically worked out a deal with the country where Iraq would actually agree to take back its own nationals. So previously there had been Iraqi nationals in the country who had old deportation orders, but for a variety of reasons, like inability to get travel documents, Iraq basically refusing to take them back. they were actually allowed to stay in the U.S. with, somewhat like no status, but they had some versions, some of them have versions of work permits, and they were just able to stay. So they built communities here. A lot of them being in Detroit area, Dearborn, Michigan area. So as part of the deal, since Iraq basically agreed to start taking people back, the U.S. basically just rounded up a whole bunch, like almost 700 something. Iraqis who were in the U.S. mostly with prior deportation orders. ACLU, there's a community out in Michigan. I used to work in Michigan, so I'm kind of familiar with that area. It was like over the weekend, about 300 or 400 of them just got rounded up. And they were, because they had prior deportation orders, they were all subject to expedited removal, meaning they don't actually have access to go in front of a judge and argue their case. They can literally just put them on. So ACLU in Michigan just jumped in, filed a bunch of class action lawsuits to stop that deportation, so at least more or less to delay them, but also give them a right to review the case. Because a lot of them were Christians from the Korean community who actually have a legitimate fear of returning to Iraq, especially in this time. So that they may be eligible for not quite asylum, but some form of related protection. So that's what the ACLU got involved with, and they were at least able to kind of stop the importing deportations and get them. So we were just basically always in a crisis reactive mode. And then as part of all that lawsuits that were going on from Hawaii, basically kind of taking the lead on it, and also Washington. Federal district courts had a bunch of blocks, injunctions on various levels, some more permanent than others. Over in the East Coast, there's also a couple of federal courts that issue. We also filed a lawsuit in the Washington district, but because Hawaii basically just like beat us to it, it became kind of moot. But it was still kind of going on. So went all the way, those injunctions went all the way up to the Supreme Court. The Trump administration challenged it, and up and down the red, the Supreme Court basically came up with this bona fide relationship rule. Basically, you may be exempt from this travel ban if you can prove that you have a bona fide relationship with someone in the U.S. or some organization or entity, school, whatever in the U.S. So if, for example, if you have a letter of admission to a U.S. university, if you already have a job offer to a university or medical institution, etc., if you're coming to take care of your sick mother who's a U.S. citizen, etc. Even the administration's interpretation of what like a bona fide relationship was all a mess. Initially, they even actually banned fiancés, and then realized like no, that's actually not even consistent with our own book in immigration law. So then they had to fix it, and then allowed fiancé, and then it came down to like, well, mother-in-law. Like, does that count? Is that close enough? It was just a whole mess. Like, how do you really define how close you are, how much interest you have in someone coming? But at least the Supreme Court at that time said that refugees who have a resettlement agency sponsorship, who the resettlement agency have already agreed to take them on, who the resettlement agency is actually being paid per person to help with the resettlement in the U.S., they don't get to come because that relationship is not on fire. I don't understand how logistically how that is not going to work, because they basically agree to take care of you, and their funding depends on the refugee coming to the U.S. How is that not a close enough relationship? And you've already been assigned. It's not like they come and then they have to individually go up to like a global lead and say, "Will you take me?" All the agreements is already signed and in place. The federal government has given them a specific agency, like you're on the hook for this person. But apparently that wasn't enough. And that got challenged a couple of times too, but so far, and Hawaii actually, when it went back down, Hawaii said like, no, that's ridiculous. Resettlement agencies, that's a good enough relationship. Went up to the Supreme Court again, and they said no, still not close enough. So that's where we're at right now, is that, close family relationships, probably okay, which also means that those who are coming on family-based petitions, they're probably okay because, since they have someone who petitioned for them in the first place, they probably have someone who could stand in for the bond application. But the refugees don't qualify under this. So a lot of the rhetoric behind the travel ban was talking about, well, we don't know, like these dangerous people who may be coming into the U.S. That's the rhetoric, that's the justification, right, that the administration has given. So this time, because of all those lawsuits, they're basically coming up with new travel restrictions to basically replace the travel ban. So September 24th, just very, very recently, they announced that this time, so there'll be more countries that will be subject to the travel restrictions. This time they actually put a little thought behind it, and in the course of determining which countries that they will put to the list, they added a couple countries to make it look less Muslim, basically. And then they actually sent out these like surveys saying, supposedly, that they sent out to about, I think, 17 countries that they identified as saying, your checks and your passport system, that's a little subpar. You fix it, or you'll be subjected to new travel restrictions. So of the 17, most comply, and these are the ones that are left that they thought it wasn't good enough. And some of them were modified too. So basically, I'm not going to go into really specifics, but basically North Korea, Syria, Chad, Yemen, Libya, Somalia, that's all more or less the travel ban. I mean, they're like very limited restrictions, but that's kind of what we deal with. Venezuela, and it only bans like the government officials and the immediate family members entry as non-immigrants. So like they can still come if they have like family-based petition or whatever. So it's politics. And also Syria. Again, we've received them for a long while, so that doesn't really change anything. But as part of it, to make it look less stringent, to say like this is just outright ban, they inserted a discretion to waive on a case-by-case basis if the denial of entry would cause undue hardship and that the person gets posed a threat to national security. It's still kind of unclear what they really mean, because like undue hardship to who? To that person? Because I'm sure whoever is banned will suffer hardship. Or is it going to be undue hardship to someone with a bona-fide relationship in the US? Like then we're back to the whole chaos war of what a bona-fide relationship mean? And again, national security is so vague. I mean, if you want to ban someone, I'm sure you can come up with some reason to say, oh no, national security interests. So we'll see. I mean, it's not effective until October 18. I know Hawaii has already announced that they're planning to challenge it. Washington is gearing up. I saw that Washington is already like sending notices to UW, asking people like, hey, if you know anyone who may be affected by this, we're interested in talking to you. So I think Washington is planning on challenging it. Okay. So part of this effort, why they came up with the new restrictions, is again to kind of fix the errors of the first and second travel ban. But the other one is because of the pending litigation. So the first and travel ban cases before the Supreme Court were originally scheduled for oral argument on October 10th. So by coming out with these new travel restrictions, the Trump administration is basically saying, oh yeah, we kind of fixed it. So yeah, it's kind of weird. Just forget about it. The Supreme Court has actually removed the case from oral argument calendar right now, and they've issued orders to both parties to argue why this isn't moot. And of course, yesterday, the Trump administration filed a motion to dismiss, asking the court to dismiss it because, arguing that they're new in light of those recent changes. Because the whole argument was like, well, we needed those travel bans in place because we were working out the system to try to like make it better. So now we came up with enhanced restrictions and enhanced vetting systems. So we don't really need the travel ban anymore. So you can all just forget about it. So that's what they're trying to do with the new restrictions. And as I mentioned, Hawaii and Washington are looking into challenging it. And then, as kind of separate from that, the administration also announced that they will reduce refugee admissions. So going back to the original travel ban, the second one halted refugee admissions for a while. So that one expires on October 24th. So kind of to preempt that going away, they basically announced that going for this fiscal year, so October 1st, there's now reduced refugee admission to only 45,000, which is the lowest it has ever been since 1980. I mean, even under the Reagan administration, it was like 68 or something like that. I mean, in some sense it could be worse, because I think like some of the really conservative groups were saying like 15,000, which is so, I mean, yeah, that's not even like one refugee camp really in some countries. but they reduced it to 45, and unfortunately this refugee number is one thing that the executive office does have they can do on its own. And then kind of in the background, which wasn't really announced, is that that they also changed the Central American minors refugee processing system. So under the Obama administration, in response to the surge of unaccompanied youth that were coming from Central America and showing up at the border, I can't remember, 60 or 70,000 of them all at one time, but that really kind of crippled our system. The Obama administration announced this Central American minors refugee processing program, such that the minors could apply for refugee status within their own country. So it's an in-country processing, and that if those kids qualify, then they can get to come to the U.S. As refugees. And then if they don't qualify as refugees, like if they don't meet the legal definition of refugees, they may be considered for a lesser program called a humanitarian parole. So basically still let you in somewhat on a temporary basis, although the Cubans were initially paroled and then we kept them. So the idea was that basically at least get you out of that and get you into the US. So in order to qualify for that program, the CAMP program, there has to be a parent in the US with legal with lawful presence, so they have to have some sort of immigration status or like withholding removal or something to actually apply for the kids back in Central America to come join them. So that's how it works. And then for the kids who don't meet the legal definition of refugee, they could be considered for parole into the US. And then the other thing, which is really interesting, is that for the kids who, like for example, if you have a kid who qualifies for a refugee, but like you really just get sent a kid all by himself to the US. So they were considering caretakers to give them parole so that they can come to the US to basically help take care of the kid. So sometimes we have situations where the kids qualify and the mom gets in with them on parole. So mid-August, the administration terminated the CAMP parole program. So the refugee processing system where the kids could qualify for refugee status, that still exists. But the parole part, so the ones who don't qualify and the caretakers who don't qualify for refugee status can't come in. And it actually really sucked because it was effective immediately. So those who have been previously granted conditional parole and just haven't gotten on a plane yet, all those were rescinded. There's several children's programs that were also affected. I'll start off with the good news first. So as part of our effort, it was NERP and Columbia Legal Services basically just ganged up on Olympia and tried to get the governor, the Washington State Congress, to pass a new law to protect some of the youths that have been showing up, especially in the surge cases in Central America. So previously in Washington courts, so I guess maybe we'll back up. Maybe I'll go to the next slide first, and then I'll come back to this. So the reason why we did this is because there is a special form of protection that's actually existed for a while called Special Immigrant Juvenile Status for kids who have been abandoned, neglected, or abused by their parents in the home country and therefore should not be returned to that situation. So in order to qualify for SIJS, the kid has to be under 21, unmarried, and that there's no parent or guardian in the US who can take care of them. And that, again, that they've been abandoned, neglected, or abused. And then they actually have to have a state court to issue an order, basically saying so. So it could be done through a dependency, it could be done through custody, it could be done through parenting plan, etc. So a lot of times what we're seeing is that they have been abused by one parent and then they're coming to the US to join the other parent, usually a mom in the US. And a lot of them are showing up on the southern border. These kids, because at the time they show up, if they are classified as an unaccompanied minor, they get special protection so that they don't get sent to the adult detention facility. They get sent to the ORR children's facility, which is just basically children's jail. But the idea is that with ORR, they're supposed to take into the best interest of the child, so instead of just detaining them indefinitely or whatever, they have to make active effort to release them and reunite them with an adult in the US who can take care of them. So that's how we see them in Washington. It's usually because they got released to the custody of a parent, relative, guardian, whatever, in Washington State. So then the kids come and then we see them in Washington State. So going back to the previous slide. So, but part of the problem was that even though the SIJS provision, the federal provision that allows kids under 21 to apply, in Washington, because of state court jurisdiction, you have to actually be under 18 to get in front of a state court judge to do these like children's proceedings like dependency, etc. So they basically left out this gap of 18 to 21-year-olds. So we pushed Olympia to write legislation to create a program such that kids who turn 18 could still get in front of the state court. So so like I said, once the kids turned 18, the state courts could not be filed. So all the necessary rulings, including that order that says, yep, you've been abandoned, neglected, abused, blah blah blah, cannot be entered. So we were basically at a mad rush to try to get these kids like birthday before they turn 18 to file, and a lot of them are usually like 16, 17-ish when they first come. I mean, can you imagine like a 5-year-old who living in that country? So they're usually like teenagers, really. So we're always just in a mad rush. So this new law signed by Governor Inslee on May 10th created this new program called Vulnerable Youth Guardianship that will allow these 18 to 21-year-olds to get in front of state court. So it went into effect in July. I think, honestly, there's only been a handful of cases we've done since then. But there's definitely been cases where previously, like maybe we came across a kid earlier that they were so close to turning 18 or they've already turned 18 where we just, sorry, we couldn't help. But now we get to go back to them and call them up like, hey, if you're still interested, come into our office. Yeah, and it's such an amazing part. I mean, immigration law reform like moves so slowly. To be in my lifetime, be able to identify an issue, to fix it, and then go back to the clients and be like, you're saved. It's so amazing feeling, really. And like NERC doesn't really do this. Like we don't write legislation. This is the first time. Like there were moments where we had to like sing to ourselves that like how to pass a bill songs. But it was like really like Columbia Legal Services took the lead. They're more like involved with the state legislation side. But to be able to pass a law on first try too. So much of it was all new to us. But I'm glad we did it. So now, like it authorizes the state court to appoint a guardian for vulnerable youth from 18 to 21 who have been abandoned, neglected, abused, and then they can order that enter order, and then we can take that order and turn it around and file for SIJS, which gives them a green card. So that was the good news. So DACA, you guys know about the program. So the program created under the Obama administration to defer deportation and give work permit to kids who walk into the U.S. as kids. So, I think the slides got mixed up. Applications that were received by September 5th that were like still pending would still be considered. But they also stopped issuing any requests for advanced parole, so those travel permission for DACA recipients. Because previously, as part of the work permit, all that stuff, was that they also get to apply for travel permits, which not only it allows them to leave the U.S. and actually have a somewhat more normal life. But the cool thing about the parole system is that some of them, like for those who maybe who have some idea of like family visa petitions, some of these kids, they may be married to, say, like a U.S. citizen, but because they came into the U.S. without authorization, they weren't actually able to get green card through marriage. But if they were able to get this advanced parole and just like really hop over the border and just like come right back in with the parole, which is a legal permission to come to the U.S., then they're golden, and then they can come back and do the green card application through marriage or whatever approval petition that they have. So this advanced parole, it was a cool, like, nifty little system that we have. So that was one way that we were actually able to switch these DACA recipients, which is a somewhat temporary status, right, to permanent residency, and like give them all the advantages of the family visa system. So, but if they cut off parole, then they can't travel, they can't use that local ticket to get to the pathway to permanent residency. So the other front is that those unaccompanied minors that I mentioned earlier that were coming from Central America, the idea for these unaccompanied minors was that there's special protections to them. In addition to like the ORR custody, the reunification with parents, they were also not subject to expedited removal. And that the asylum office, which tends to be the nicer agency to deal with immigration proceedings in general, has initial jurisdiction to asylum claims. So all these kids are actually all placed in deportation proceedings. They have to go in front of a penal judge. But if they have been designated as an accompanied minor, they actually get to file the asylum application with the nicer asylum office.
And they also have an exemption to the filing deadline. So normally people have to file for asylum within 1 year. So these kids were basically given no deadline. Which is very, like, can you imagine interviewing like an 8-year-old trying to get the story? Like, it may be before they're like 10, before they're actually just emotionally mature enough to talk about it. We also had another case yesterday where like the kid just initially just didn't disclose any abuse by the dad because he was like too afraid to get his dad in trouble. There's just so much shame and psychological issues when you're dealing with abused kids. But so it took a while for him to warm up to us even like tell the story. And like maybe something else happened. In that case, it's because he actually heard that his sister back home was being abused by his dad, and then that convinced him to talk about it. But that by then, like more than 1 year has passed. And, like these type of deadline issues are they're there for a reason. Those protections are there for a reason. But as part of the administration, like kind of clamping down on this, is that the government attorneys and immigration courts are now arguing that they lose their unaccompanied minor status if they have aged out. So if they like basically turn over 18, or they've been reunited with their parents such that they're no longer unaccompanied. And then if you strip them of the protection, then the asylum office has no jurisdiction to grant them asylum. What's interesting in the argument is that I've had several cases that were approved by the asylum office, like before they started arguing this. They're also trying to kind of like backdoor into it and saying like, well, if they have no jurisdiction, the asylum office has no power to grant them asylum anyway, so that the asylum grant is null, which is bonkers to me. Because like once it's approved, like you don't get to say, oh, my mistake. But that's what they're arguing. And that now the immigration judges are now authorized to revisit the UAC designation. So when they're in court, they can strip them of the status and then strip them of these protections. We're obviously fighting tooth and nail on it. We haven't had one yet where the IG actually stripped them, and this is like very, very recent. I think the immigration judge order came out earlier this week, earlier last week. It's quite a tell time now. So yeah, that's kind of what's in the background of what we're doing. So you for 2 slides. So yeah. So going back to the DACA. So I mean, immediately after Trump announced it, he was like, oh yeah, what about your promise that you'll be good for these DACA people? It's like, oh wait, no, I didn't mean it like that. I mean, Congress will now have 6 months to fix it. I mean, he started walking back the issue as soon as he issued it, right? I think, so kind of in the works already, which has been raised before. I mean, way back when, before the Obama administration even announced DACA, they had some proposed legislation called the DREAM Act. So they're trying to revise some version of it. So DREAM Act 2017, which has bipartisan support. So the idea is that they will grant these DACA kids conditional residency for 8 years, and that that could convert to a permanent residency if they go to college, have to work for X amount of time, or serve in the military. And then since if they can get the green card, then they will be put on a pathway to citizenship. And it also has all these financial aid and college affordability provisions in it, which is really cool. And then that was kind of like in the works, and that's still somewhat there. We'll see how it goes. But now they have a deadline, right? Because they basically have to pass something before March 5th if you're gonna save the Dreamers, if you're gonna save the DACA kids. And then on the more conservative side, they put forward 2 proposed legislation. One is the REC, or the Recognizing American Children's Act, something like that, and Succeed Act, which is actually more recent. So basically, there's more restrictions. Like they added a lot more restrictions about who can qualify. Like I think one of the requirements was saying that you actually have to be in current DACA status. So all the people who couldn't renew because the Trump administration rescinded it, all the people who DACA applications actually expired and they never got around to renewing it, usually because of financial issues, like they're all screwed basically. So there's more restrictions. There's a much smaller number that could qualify. There's also a longer path to citizenship. So like under this, to see that, so instead of 13, I think it's like 15 years. They actually have more years that they have to be in conditional residency. And they have more restrictions, like there's more conditions to residency. Like the REC Act, for example, requires that you to be in school for a certain amount of time, work for a certain amount of time, but if you switch, like say you work for 2 years and then go to community college, then you actually shoot yourself in the foot and then knock yourself out of conditional residency. So they have like really strict requirements. The Succeed Act gives a more combination path so that you can like work and go to school at the same time. But they also have like a lot of conditions. So one of them is that you give up all other forms of immigration relief if you violate the conditions of this program. Yeah, and then you also give up the right to due process. So like you don't get to go in front of the immigration judge. Like if they terminate, they can just like put you on a plane basically. Yeah, you have to like sign this paper saying I give up my right. And then it also prevents sponsoring of family members. So like, if you become a green card holder or you're a citizen, you can petition for your family members. So under this program, if you get your residency through these acts, you can't bring your family members over. So to be honest, I don't think it would garner bipartisan support certainly, but I don't think it would really pass. But then again, I also don't think that any of this will pass in 2017. I think they're gonna wait until 2018, which is why it's so important now to push them. I mean, now that, in some sense, like, on the silver lining, maybe it is better that the DACA program has a deadline, because we've been dragging our foot on this issue, and we just have been passing the buck on this issue for years. And as long as the DACA program existed, it was almost less urgent, because whatever, they're not going to get deported, they can stay, we'll figure it out later. But now they're not. This is the moment to do it, right? So I think it does kind of light a fire under them, and with a lot of the demonstrations and protests going on. I mean, this is like the one group where you actually have some bipartisan support that even for the most conservative, they think that the children maybe should be safe. I think this is really the time to really build up the political pressure to get them to pass. The other issue is at what cost, I think is the issue. I personally think that there will be some form of protection that will probably come forward. What that will look like is unclear. And then but then what I'm worried about is at what cost are we going to do this? Is it going to do border stuff? Increasing interior enforcement, which seems to be the language nowadays. Who else are we screwing in order to get these for the kids?
So what's that part of the language? Was if they do something with DACA, they want to get so much money for a border wall.
Yeah, and then now they're saying, oh no, I didn't really mean border. I meant interior enforcement, which is even more dangerous, because then you're going after people who've been here for many, many, many years, and then you're actually separating community. Race Act, just other crazy conservative act. So currently, both of them are being, so there's actually two versions of it. It's being referred to the Senate Committee on the Judiciary. It basically all but eliminates family petition, but for spouses and minor children. So it gets rid of the sibling categories, it gets rid of the parent categories, it also gets rid of the adult children categories. And then you'll be on this merit-based point system, where you get points depending on your age. If you have an your English fluency, whether you have a STEM degree. I also actually look at the degree issue. You get certain points if you're a high school graduate, college graduate, and then all the rest are STEM. So if you have a non-STEM, higher education, I apparently am not worth it. If you have a high income job offer, if you have investment defined as over $1 million. Oh my gosh! So they have this merit-based system. And the interesting thing is that this merit-based system actually doesn't even take into consideration what the economic needs are. If we have a specific need for nurses, or we have a specific need for certain areas, it actually doesn't give you points or whatever on that. The business community has almost no input on what type of people that they actually want to bring in, who they want to hire. So I think, and then also we reduced refugee admission to 50,000, which this is kind of in the works. So the Trump administration has already reduced it to 45. So this is even lower than the Race Act.
Does it include, currently we have patients in our clinic who have medical degrees or engineering degrees and they can't practice here, so would it include a pathway for people to be able to practice here, or do they actually?
No, it's just a matter of coming into the US. It's you have to earn a certain amount of points, I think 30, before you can even submit the visa application. Yeah, and part of it, one is that they have to have a high income job offer, so unless they already have a job in line, I don't know.
Yeah.
But it's interesting how many people got stopped at the travel ban when it happened, who were bona fide in the U.S. with legal status, who were doctors,
Yeah.
who were
Yeah, I mean that was part of
who were
the first one. The first rollout doesn't even allow people with green cards to come back in, which is also unconstitutional. So then they ended up fixing that issue. I mean, like the whole enforcement was such a hodgepodge mess. So that's why they're trying to get around it with this new travel restrictions, which is supposedly more well thought out. Also, I also personally don't think this will pass because like it pisses off so many different sectors. Like the business communities aren't happy because they get no say. Like those who are supportive of legal immigration also get screwed because you cut off a lot of programs. Like basically, you're just I don't know. When you take away so many, I just don't think even for the most restrictive, I mean, maybe not the most restrictive, you still ban it. But other than that, I think it also doesn't have enough support. Okay, so enforcement priority. So the travel ban and all that are what got in the news, but kind of actually a few days before the travel ban, they issued several executive orders that increase enforcement efforts and enforcement priorities. And this is kind of how it will roll out. So one of the concerns is that there will be increased risk of applying for immigration benefit. So there are certain situations where when immigration agencies adjudicate application for asylum, applications for green card, if they don't approve the case, I mean, they have all your information now. Would they actually refer you to deportation proceedings, put you in deportation proceedings? So with asylum cases, that's always been the case. There's always that risk. With other cases, U visas, for example, DACA, for example, they generally have none. Like if they deny, they just deny. But they don't, actually take enforcement to actually put you in deportation, with the exception of like really extreme cases where like, oh wait, this wanted person on the FBI watch list is like, okay, well now we have information on them. But with the exception of those extreme cases, they generally don't get any adverse reaction other than just being denied. But now with the issuance of the February 20 Department of Homeland Security memorandum, we were concerned about potential increased risk for filing affirmative applications with the immigration agency. As of June, the Seattle office here says they haven't received any new memorandum telling them otherwise or what to do. And we haven't seen a particularly uptick in people who are being denied and then put in deportation proceedings. So we'll see. I mean, it could be a matter of time rollout, right? Or it could be a matter of just like, again, with the travel ban, which they issue an executive order, but then didn't tell anyone else how to actually go about doing it. So it may be one of those situations. We'll see. But what we have been seeing is the expansion of enforcement priorities. So previously under the Obama administration, or really under most of the prior administrations, there's always been just a realistic recognition that we have limited resources. You can't deport all 11, 12 million people. So you focus on on those with criminal records, etc. Or like recent arrivals or whatnot. Like those are the priorities of the previous Bush, Obama administrations, right? But under the new February 2017 memorandum, it basically expanded the enforcement priorities to anyone who's been convicted of a criminal offense, abuse of program related to public benefits, engage in fraud, are subject to final order removal, and in the judgment of an immigration officer, otherwise pose a risk to public security or public safety or national security. So basically, a catch-all provision that's like, if you want to deport them, you can determine that he is worthy of deportation. Like this.
And what is an immigration officer? That's not a judge.
No, it's just like anyone with a ICE agent.
Pretend badge.
Yeah. So that's basically like everyone. So, and we have seen increased detention of people who qualify under those, which is basically everyone. Especially the people who are subject to final order removal. Like I say, in previous years, for humanitarian reasons, resource reasons, geopolitical reasons, like if someone has a final order deportation and they can't actually effectuate the deportation, we'll just let them stay for a little bit, depending on the country. But it also means that previously, like they may have final order deportation, but they were actually able to more or less go back to the normal life, go to work, build families. But now those people are at extreme risk because the thing about having a final order deportation is that they don't have to haul you in court and go through the process all over again. They can just reinstate that old deportation order and put you on a plane. So these are the low-hanging fruit for ICE enforcement agencies, right? Like it's so easy basically for them. So now, I mean, a lot of people, I mean, you may have seen in some of the news, like people who have been here forever are now at increased risk and actually being arrested and detained and deported for it. So, and we're also seeing decrease in prosecutorial discretion. So again, like in previous years, when they, like, basically if they come across a case where, you know, the person is an outstanding member of the community, has kids here, no criminal records, it was just basically them recognizing, you're not. And they may administratively close the case, or just like basically put you on the books. But now there have been increase in reopening cases that were previously shelved. And then there's also been increase in the ICE attorney, the OCC office, denying joining motion. So previously we would like maybe work out a deal with the prosecutor being like, hey, just let the guy go, he's a good guy. Like just shelve the case. And we're not saying that he gets any status, he doesn't gain anything from it, but just like he's not worth your time, basically. But now they won't join in on the deal. So instead what we have been seeing is the interior enforcement is really stepped up. So when you have those increased enforcement, this is why those sanctuary policies are so important. Because it basically prevents how ICE gets to them in the first place, or at least try to mediate that. So, caveat, sanctuary policy, there's obviously no universal terms for it. It really just generally refers to policies that prevent local enforcement of immigration law. So the city, the municipality, using their own resources to help with immigration enforcement. For example, maybe the local police won't cooperate with ICE, that local jails won't hold people on ICE detainers. But it does not mean the ICE agents cannot, on their own, go into community and do their work. But there's been, I mean, King County has already had ordinances on the book that limits like cooperation with ICE in certain circumstances, depending on like the person's criminal records, etc. But there's also been a recent resolution where they kind of reaffirm a lot of the same issues. I know we've been talking to the sheriff's office, the downtown city, which actually has jurisdiction over a lot of county jails, etc. So in King County area, we're actually probably all right. But then in response to all the sanctuary policies, is that, go to the next slide, is that there's been ICE has been going into areas that they wouldn't in the past have gone into. So there's a 2011 memo describing sensitive locations where ICE is basically supposed to like at least steer clear of, including schools, hospitals, religious institutions, religious ceremonies, public demonstrations. Courthouses actually are not on the list, and we have seen reports of plainclothes ICE officers basically stalking outside of courthouses. So you have a client who maybe go in on like a DB case against her abuser, and then she comes out trying to get like a protection order or something like that, and she comes out and they arrest her.
Are the medical records of people without status, are they protected under HIPAA and other?
Yeah, so I mean, your medical records have HIPAA, so I think like if you really, maybe you need to think about, is it really necessary for you to write up notes about the person's immigration status? I mean, the HIPAA provisions are much stronger in any case than the other confidentiality rules.
And California, Jerry Brown just extended some protections today. Do you know anything about it?
Yeah, so again, it's just like a lot of reaction, right? So like California, over in Texas, for example, they've been suing back on the sanctuary policies. Actually, the case isn't going so well on the conservative side down there. So there's always been this issue. I mean, this sanctuary policy location, like sanctuary policies have been litigated. I mean, like before the Arizona SB 1070 before the Alabama showing people, like that's been going on for a while. But I think now more than ever it's more important because there has been an increased interior enforcement that those policies really do make a difference in terms of how the person gets into detention and ICE. But now they say, oh, since you have all these sanctuary localities that protect these people in sensitive locations, ICE agents, they have no choice, but because they can't just like wait outside the jailhouses anymore, and the jails won't hold the immigrant for them. So now they actually have to go out into the community and do raids or like stalk outside the courtroom house. That's their plea. That we made them do this. So now they are in certain situations they are going near these sensitive locations, like or maybe like close enough to it. So maybe they can't go into the school, but they'll like wait at the school bus stop that's a few blocks down the road or something like that.
So the one sensitive area in the hospital was a couple weeks ago, I think, in Texas, where they came where there's a couple with their little child that was having surgery. So I'm just curious about what you think in terms of hospitals.
I think certainly in public areas, I think you should have signs about like thinking about what is public area, what is private areas. Like if someone comes, if ICE officers show up, I think you can direct your patients to the more private areas because they actually have business being at the facilities, so that they're not just kind of out for grab out in the public areas, out in the lobby, out in the sidewalk or whatever. So you may want to think about like which are your public areas, which are your private areas, because in order for the ICE officers to go into private areas, they have to have a search warrant.
So going back to Carrie's earlier question, the advice was not to ask patients about their vendor document.
Well, I mean, I think in some cases you kind of have to, like if you're going through like financial provisions, like some of it does, but then I think you just have to think about like why am I asking this, and like where am I putting the information.
Has there been a case where they've taken our records and used them?
I haven't seen it, mostly because those records are so hard to get, and there are easier ways to get admission of undocumented status besides going through a HIPAA medical records. I mean, to be honest, the easiest way is they just straight up ask the immigrant, and the immigrants are too honest to talk. So kind of touch on what we've been busy with. We challenged the travel bans. We have a couple of lawsuits on that. We also challenged the COP program, which is a secret program, and they were just blackballing or delaying cases that were filed by Muslim Americans applying for immigration benefits. So like if you have a Muslim American name and you wonder why your citizenship application has been sitting for 10 years and you haven't heard, it may be in the COP black hole. So we challenged that COP program. We won a preliminary injunction against the Department of Justice cease and desist letter. I don't know if you guys have heard about it. So a few weeks after the travel ban lawsuit, the DOJ actually sent us a letter saying cease and desist with some of your pro se work. So like part of what we do is that we help people who don't have representation in immigration courts kind of do like limited assistance work, such as like helping them fill out forms, helping them submit requests to transfer the case, things like that. We don't go in as full representation because we don't have the resources to represent everyone who walks through our doors. This is basically a sort of like a legal aid version of limited assistance. So the administration say, no, you can't do that. So you're basically left with this choice of you either help everyone or you help no one. And it's actually kind of funny because we went into the first trial over the temporary injunction and tried to ask the motive, and the attorney basically just admitted it, like, oh yeah, we want them to help less people. Can you be less subtle, please? The judge wasn't satisfied. So we won the temporary injunction, and then we won the preliminary injunction against them. So the cease and desist letter can't be enforced against us or similar nonprofit organizations. So that was the other worry. Like at that time, we were the only one who got the letters. We asked our sister organizations across the country, like, hey, have you seen this? And no one has. So it seemed to be a pretty specific targeting of NERC, and the timing seemed a bit questionable. Not only does the injunction protect us, but it also protects other organizations that do similar across the country. And that case would probably drag on for years. But yeah, so that's It's been an interesting case. We also want the ability to apply for permanent residency for people who've been granted temporary protected status if they have an approval petition. So this is actually Chris John's case, Chris John Matt's case. So that's only in 9th Circuit and I think 6th Circuit, so it's not countrywide. So yeah, maybe other people should consider moving to the US Coast. We're also fighting for the right to counsel for children deportation proceedings. So if you don't know, people who are in deportation proceedings don't have a right to appointed counsel. So imagine someone who doesn't speak English, doesn't have high education, not familiar with immigration law, which is complicated even for US attorneys, and somehow they are supposed to defend themselves against someone who's making like 6-figure government-trained attorney, including kids. So we thought, no, like there's just something wrong with this picture when you have like a 6-year-old sitting in one chair with a mic to her, and the government prosecutor is sitting on the other chair with her. Like that just doesn't seem right. So we're fighting for the right to counsel for children. We have previously won the right to counsel for mentally incompetent detainees, so we're trying to push on the boundary on that. We're also defending the right to bond hearings for detained immigrants. That case actually may end up going to Supreme Court, so Matt may be arguing in front of Supreme Court come this fall. We'll see. We recently also filed a lawsuit along with our partner agencies challenging the treatment of pregnant women who are detained. Because I don't know if you saw the news and also on NPR, but like one of our clients suffered a miscarriage in detention because she wasn't given proper medical attention. But previously, there's actually a policy that says, like, you know, if you could, just avoid detaining pregnant women. But now, I mean, as a class suit, like there's several people who are in that lawsuit. We also have a challenge the 1-year filing deadline hurdles for asylum seekers, like basically just getting them the right to apply for asylum. And we also have a civil suit this week, like Matt just argued it, was it Tuesday? Against a corrupt ICE attorney who actually submitted forged documents in court to prove her client's case. Oh yeah, he got criminally prosecuted. He gave up his law license. He got fired, etc., etc. But that's after the U.S. Attorney General's office like investigated him, and that's after we brought it to their attention and we sued them over it. So that civil suit is still ongoing. I think now more than ever, we are doing like know your rights sessions so people just so they know, have an emergency safety plan in place and kind of have an idea of what the rights are and know what to do.
How do you tell the difference between a judicial warrant and a ICE warrant?
Yeah, so the judicial warrants have the headings of a court signed by a low judge. An ICE warrant is just signed by an immigration officer who has no judicial power. It's usually just got issued on their own paper. So the ACLU actually has pictures of like what a sample judicial warrant would look like and what a sample ICE warrant. And it's not even a warrant. I hate it when they call them that. I also hate it when they call themselves police when they're not police. But yeah, so you can look at the pictures to recognize like what you're dealing with. I know like the King County Public Health has like even done a training on what to look for, and they've also issued a policy on what to do with if ICE agents come.
Oh, because they can even come to the hospital, just so we... Right.
I mean, if they have a search warrant, they can come in, but then only for specific reasons, like they don't get to just roam around. But then we also have know your rights to the general community on just like basic things like you have a right to remain silent. Because like I said, one of the most common ways is that they just straight up tell immigration, oh yeah, no, I was born in Mexico, I came here, blah.
Bring this to a close. I want everybody to thank Maggie for coming.